Good morning. This is the case where you have to concentrate little bit because the employees who is dealt by the government, central government, state government. If it is state government where there is no administrative tribunal which was earlier existing, and the central government, central administrative tribunal is in force. So the thing is how the advocates dealt the case bravely despite the fact that they lost the cases at too many levels. And another aspect is also dealt in this judgment which is I am going to share, that what compels the advocate to withdraw the OA filed by him. That I will discuss now. Now the case is AR 2024 Supreme Court 4046. AR 2024 Supreme Court 4046. Mool Chandra versus Union of India. Mool Chandra versus Union of India. The appellant seems to be Indian Statistical Service Deputy Director. Unfortunately, what had happened, his wife lodged a complaint stating that he is residing with another wife and neglected the wife and children. So the initially charge was framed. CCS rules 14 was issued. This is a central government CCA rules. CCA rules 1965. Then what had happened subsequently, pending inquiry, officer was up. Pending inquiry, the first wife withdrew her complaint stating that there was a misunderstanding. But however, the inquiry officer, by believing the circumstances and other evidences, dismissed him from service. He challenged that then by filing OA, and that OA was disposed with some observation. Therefore, the disciplinary authority again confirmed the dismissal from service, taking advice of UPSC. Then what had happened? Thereafter, some OA was filed, and that way OA seems to have been withdrawn by the counsel for the petitioner. Thereafter, the counsel, the Mool Chandra seems to have filed another application with the condonation of delay. That delay application was dismissed. Therefore, 425 days delay was dismissed. That against that dismissal order and review application, the petitioner filed SLP before the Supreme Court. Supreme Court has held that the reasons given by the petitioner not discussed, it seems to be reasonable. Therefore, the condonation of delay application was dismissal of condonation of delay application was set aside, and that was allowed. But unfortunately, some law of equity was extended to the Mool Chandra, stating that since he is aged about 60 years, instead of remanding back, he set aside the order, somewhat exceeding little bit judicial review of administrative. These all are the words you have to carefully understand: judicial activism, judicial overactivism, and independency of three pillars of the democracy: executive, legislation, and judiciary. So, but since it is Supreme Court, finally the relief was granted to him, and he was directed to be considered as reinstated with all consequential benefit. And that has to be settled within 3 months. Best order was given to him. So what I would like to discuss with you was probably sometimes it happens the members or the chairman of the administrative tribunals compel some advocates to withdraw it by threatening. That threatening, they are not understanding. They ought not to have threatened whether are you withdrawing or am I to dismiss with some observation, other thing. I could not understand this sort of behavior should also be checked or considered for review. Okay, go through the judgment. It will be helpful, and you appreciate the advocate who subsequently appeared. He took much strain to take this case to Supreme Court and got relief of this unfortunate employee. Best wishes.